Hi everyone, today we're going to be talking about whether an injured worker in California can sue his or her employer if there is an accepted workers' compensation claim that they have against their employer. So the answer to that is it depends, and I know that that is a frustrating response for most people, but let me explain. Generally speaking, no, you cannot sue your employer separately, and what I mean by that is you can't file a civil suit against your employer for the same injury that's being covered by your workers' compensation claim. Generally speaking, that is true. The reason that that's true is because back when the workers' compensation scheme was being developed in the state of California, essentially this was a bargain, a give and take between employees and employers, essentially speaking. So the employees, what they got by having the workers' compensation scheme in place is they got the right to speedy benefits. Now, I understand that doesn't necessarily happen all the time, but that was what was supposed to happen. And essentially what workers' compensation benefits and the whole scheme has been created to be in California is a benefits delivery system. I'll say it again. Workers' compensation in California is supposed to be a benefits delivery system, which means that even if you have been waiting and even if you have had to jump through lots of hoops, believe it or not, it's actually a lot less painful than it is if you were to go through the civil court system, which is so incredibly backlogged, and it would take much longer for you to get your benefits. So that's what employees got as part of that bargain. Now, what employees had to give as part of that bargain was their right to sue in civil court. So that's why workers' compensation in California it's deemed an exclusive remedy. That is like your only remedy for a work injury that occurred. Now, the reason why I started this video with saying that it depends is because there are exceptions, just like there are exceptions to everything. So some of the exceptions are things that are covered by the Constitution, whether it's California's Constitution or whether it's federal Constitution. So, for example, if you are suffering from a stress claim, if that is your workers' compensation claim, let's say sexual harassment. Well, sexual harassment is one of those things where, yes, the stress can be covered under workers' compensation if it's accepted, but depending on the circumstances, you might also be able to sue in civil court because you were discriminated against based on a protected class. In this example, that protected class is sex. So if you are discriminated against based on sex or gender, sexual orientation, race, ethnicity, nationality, religion, those things are covered under the California Constitution, and sadly under the federal Constitution. The one thing that's missing is sexual orientation or sexual preference. That is not covered under the federal law. Not yet, anyway. So that's my answer to that question. I know a lot of you have that question, and if it's taking forever for you to get your benefits, and if you need help with that, feel free to let me know. I have my contact information in the description box below, and of course, ask any other questions. I'll make a video about it in the near future, and until then, I wish you the most fulfilling life possible. All right, take care. Bye.